How are you doing today? My name is Mutiawa Conrad, a lawyer and a private law tutorial um, assistant. Please always feel free to always reach out to us in case you need private law classes. You can always contact us, and our number is just below in the description box. So today, basically, we're going to be looking at the offense of defilement, and we will, in this class, proceed to define the offense, to give the legal framework within which the offense operates. Then we'll also, of course, examine the ingredients of this offense, and we'll also go ahead to look at the punishment and also make a comprehensive analysis of cases and what actually courts have held on the same. And of course, in between that discussion, we'll also be looking at a number of legal principles that govern this offense. Please, again, do not forget to subscribe, like, and share my channel, and also turn on your notification so that you're always able to get these classes. So let's start right away with the offense of defilement, and basically the law that provides for this offense is under section 129 subsection 1 of the Penal Code Act. It provides for the offense of defilement. And also of interest is the punishment, which is also under the same section 129 clause 1, which provides for a punishment of life imprisonment where an accused person has been successfully convicted by a criminal law court. Let's now proceed to look at the ingredients of defilement. This type of defilement normally is also referred to as simple defilement. The reason why they add simple is because there is also another type of defilement known as aggravated defilement, which we'll be looking at in a later session a little bit more in detail. So this defilement, also known as simple defilement, the ingredients of this offense were clearly laid down in the case of Uganda versus Yahweh John. Is criminal session number 0127 of 2015. You look at the judgment of Justice Stephen Mubiru. He lays down the ingredients of this offense as follows. Ingredient number 1, that the victim was below 18 years. So the victim must have been below 18 years. We'll be looking at these ingredients a little bit more in detail later, but for now we just want to set the record straight by stating them a little bit more clearly. The second ingredient of the offense is that that a sexual act was performed on the victim. So there must have been a performance of a sexual act, and we'll be looking at that in detail. Then thirdly, the other ingredient is that it is the accused who performed the sexual act on the victim, and this last ingredient is always intended to put the accused person on the scene of crime. Let's now proceed to evaluate each of these ingredients a little bit more in detail, and the first ingredient being that the victim was below 18 years. Now, age is really very, very important. There cannot be defilement where the victim is actually above 18 years. There can be no defilement at all. So, ladies and gentlemen, this is really important to note at this juncture. Let's now proceed to look at a number of cases on the same, and I invite you to look at the case of Uganda versus Kagoro Godfrey. This is High Court Criminal Session case number 141 of 2002, and in that case, court held that age is proved by, if you want to prove age of the victim, you prove it by, number 1, production of a birth certificate. Okay, then number 2, the testimony of the parents. You can also bring parents as witnesses who can give testimony as to the age of the girl. Then number 3, the court's own observation. Okay, do not forget the principle that courts or a court or a judge is an expert of all experts. So the judge can always make an observation of the girl, and then the judge can draw himself or herself to the conclusion that actually the girl is below the age of 18, especially for those cases where the girl can clearly be seen. You know, there is a girl that you can see and clearly it's very, very visible. Sometimes it can be a bit confusing where, for example, a girl is maybe around 17 years or 17 years and a half, but where it's possible for the judge, he or she can use their discretion to actually draw themselves to the conclusion as to the age. Then also, according to that case, number 4 is common sense assessment of the age of the child. So common sense can also be used in terms, again, of observation and other aspects related to the same. Also of interest on that ingredient is the case of Safari Innocent versus Uganda. This is Criminal Appeal number 2 of 1995. And in this case, a court went on to hold, and this is a Supreme Court decision where the court held that proof of the exact age is not essential. Only proof that the girl is below 18 years is a must. Okay, so proving the exact age is not necessary. All you have to show is that this girl is actually below 18 years. And if you're able to show this as prosecution, then definitely you would have attained the test, and you would have satisfied the requirements of the first ingredient of the offense, which is that the victim was or is below 18 years. Let's now proceed to look at the second ingredient, which is proof of a sexual act. So you must always prove that indeed there was a sexual act committed by the man or by the accused person. And on the aspect of proof of a sexual act, I encourage you to look at section 129, subsection 7A of the Penal Code Act, which actually defines a sexual act as penetration of the vagina, mouth, or anus, however slight, of any person by a sexual act. Okay, very, very, very important. So a sexual act, the law is very clear on what amounts to a sexual act. Okay, it's penetration of either the vagina, the mouth, or anus, however slight the penetration. It doesn't matter. The penetration doesn't necessarily have to be full, but even if it's halfway or quarter way, even if it's by a small inch, it is sufficient, and it amounts to a sexual act as envisioned under section 129 subsection 7A of the Penal Code Act. Also of interest to you is section 129 subsection 7B of the Penal Code Act, and that section basically provides that the unlawful use of any object or organ by a person on another person's sexual organ. So that section, subsection B, also goes on to define what amounts to a sexual act. So besides the first explanation that I gave you, but a sexual act can also include the unlawful use of any object or organ by a person on another person's sexual organ. And this subsection covers things like, using dildos, using instruments, using any other thing, using your hands or your fingers, okay, on the other party's sexual organ. So the law under that section clearly also covers that, and it is also defined by the law to amount to a sexual act capable of making a person to be charged under that offense. Also of interest under that second element is the case of Remigius Chiwanuka versus Uganda. It is SC Criminal Appeal number 41 of 1995. This case is unreported, but I'm sure you can find it online. In that case, court held that proof of penetration is established by the victim's evidence, medical evidence, and any other cogent evidence. So how do you prove that there was indeed penetration or a sexual act? Okay, evidence of the victim. Court can convict you basing on the evidence of the victim, but court can also convict basing on cogent evidence. Court can also rely on medical evidence. Okay, all these are types of evidences that the court can rely on to prove that indeed there was a sexual act. Also of interest, again, still on the second element, is the case of Gerald Gwayambadde versus Uganda. This is a case of 1970, High Court Bullet, page 156. And in that case, basically, court held that the slightest penetration is enough to prove the ingredient of sexual act. Okay, any slightest penetration, it's enough, and this is what I earlier was laboring to explain. Let's now proceed and look at the third ingredient of the offense of defilement, which is that the accused performed the sexual act on the victim. Okay, very important. Look at the case of Uganda versus Yahweh John, which I already shared with you, CS number 0127 of 2015. It's unreported, but judgment of Justice Stephen Mubiru, where he held that this ingredient is satisfied by adducing evidence direct or circumstantial, placing the accused at the scene of crime as the perpetrator of the offense. So the moment you're able to bring any sort of evidence, direct evidence, circumstantial evidence, to place the accused person on the scene of crime, then you would have satisfied this ingredient. It's also important to note, ladies and gentlemen, very, very important, please note that not knowing the victim's age is immaterial in defilement cases. Okay, the fact that the accused person says that at the time I defiled this young girl, the girl actually looked as if she was 30 years because she was fat, she was very huge, and therefore I honestly did not know that the girl was young, is in itself not a defense, and the law does not recognize that. The moment the girl is below 18 years, even if in fact she looked to be 32, or she was huge, or she really looked mature, or in fact, even if she told you that she was of an older age, in itself does not matter in offenses of defilement. Also, on the third ingredient of interest to you is section 144 of the Penal Code Act, which provides that knowledge of age of female is immaterial in offenses against in respect of a woman or a girl. Okay, so the knowledge of age of a female is immaterial. Okay, it's really very material in offenses against or in respect of a woman or girl. I also finally encourage you to look at the case of Tumhairwe Vincent versus Uganda. This is criminal appeal number 29 of 1997, where a court held that the accused, not knowing that the girl was below 18 years, was in fact no defense. So court stated that the accused person could not bring a defense or could not argue that they genuinely and honestly did not know that in fact the victim or girl was below 18 years. So ladies and gentlemen, that is it on the offense of defilement. Once again, I encourage you to subscribe, like and share, and also turn on the notification bell. And for students that really require the extra training and polishing and mentorship and guidance, please always feel free to reach out to us, and our contacts are down in the description bar. Let's meet again in another class. See you. Bye-bye.